we allow a committee, 3 to 5 hourly people, to be on a committee to review discharges of employers. So we, senior management, approve a recommendation by a supervisor to terminate an employee. The employee is terminated. The employee is then given the opportunity to appeal that termination to a peer review committee. You're entitled, under any review, whether it be arbitration, the NLRB, the courts, who have reviewed this practice, they have said unanimously that as long as you, the employer, who prepare whatever rules you want, apply the rules consistently, this is a process that will be valid and be upheld. And you can, for example, here's a policy within peer review that I would recommend strongly. You have the person who is appealing to the peer review sign a document releasing from liability or privacy rights anyone that's part of the process, the employer, the committee, because we're going to be talking about your private rights. So you waive any right to complain. So now everything can be raised. I love it. There is, however, one drawback to it. And I have seen this for now about 30 years working. What's the only drawback? The only drawback. Can you think of a drawback?
You have to be careful with family.
Well, I mean, you're going to give training about how you handle a review. I don't know what you mean about family.
Well, in a plant, you have several generations of working. So
you could have several
people. You can opt people out, I guess, of the peer review.
You can
relative.
pick your policy. You can say relatives of the employee are not eligible to be on the peer review committee. What you could also do is have names of people who volunteer to be on the committee. Okay, volunteer. Love that word. Your continuous improvement teams, your focus groups, your problem-solving teams. Try to get volunteers. Try to get people to be stakeholders. So you have 25, 30, 40 volunteers, put their name in a hat, and have people pick names out of the hat. Other examples of things that I've seen work, let's say the peer review committee is 3 people. The 2 people whose names are pulled out of a hat, they pick the 3rd one. But that doesn't mean you can't develop rules like relatives are ineligible. So you have the rules. What's the one downside? That what you raised was a very good point to build into the process. Yes?
They give the person a route back?
You think that's a downside?
If you really didn't want, if you really wanted them terminated, and the employees vote for the person, yeah.
That's a risk. What do you think the likelihood of that happening if the employee was terminated for valid reasons?
Greatly diminished.
Excuse me?
Greatly diminished.
The one downside is that the peers are harder than we in judging fellow employees. I would say to companies, please go to the church of your choice or synagogue of your choice and pray. Or go to the bar of your choice and pray. That the committee, once in a while, overrides your decision. They know more about what really is going on than we do. And on that basis, if we still have objective facts on which we rely to execute the termination, wow, they're not going to override it. Is there a risk? I suppose there is, but maybe we need to keep our feet to the fire and keep our managers' feet to the fire so that they do what we say. Now, there is something else that we can talk about here, and it's called ADR. Has anybody ever heard of ADR? Alternative Dispute Resolution? Alternative Dispute Resolution? You can tie peer review to ADR, meaning that anyone who loses at the peer review level has one more appeal, and that is to binding arbitration. Now, the reason I like that is because we're now creating opportunities, symbols, if you will, of showing how much we care to protect our employees. I like it also because the Supreme Court of the United States just happened to say, some years ago, that employers can make ADR a condition of employment. Meaning, if someone doesn't agree to go to ADR, you don't have to hire one, or you can terminate one. Or you can force one to go to ADR, and if he or she doesn't want to go to arbitration after being terminated, that employee loses his or her right to go into state or federal court to appeal the job-related decision. Pretty powerful, isn't it? Now, when you do that, I mean, statistically, if you ask me, Steve, we have 100 employees. How many times, let's say in a 10-year period, would there be an ADR event? Once or twice in 10 years? How many times in a year might there be, if there are 20 discharges, how many would be a peer review event? 2 or 3? Maybe? Why is it that? Because if I'm guilty, and I know I'm guilty, and I've got to take my dirty laundry and air it to my peers, and then have those peers review it and judge it, I'm going to be looked at as being stupid, careless, and all those other adjectives that are going to make somebody feel, why should I go to peer review?